Thank you, Mr. Chairman. Professor Chen, your figure that 17% of the ITC patents are essential, or cases are essentially large U.S. companies to U.S. companies exploiting the ITC in order to have a battle in a second venue.
In order to have a what?
In order to have a battle in a second venue, whether it's Broadcom versus Qualcomm or Kodak, Apple, or Motorola. Were these, in your opinion, part of the original intent? Did we intend to have major U.S. entities in ITC over what is often essentially the importation of a component?
That's a great question. And just to get clear on the numbers, my 2008 report shows that actually about 60% of cases involve competitors or large companies being sued. So it's a larger percentage than 17. That's the number that applies to foreign companies being sued by domestic industries.
So in fact, it's the majority of companies are simply seeking an alternate venue not originally intended in the statute.
That's correct. I believe that 2/3 of cases in the ITC have a district court counterpart. So they're not cases that could not have been brought in district court. In fact, they are being brought in district court as well. But here I think is where the ITC has provided a service to our economy and to these companies by providing a faster venue for disputes to be resolved.
And this is a committee that has been working on the rocket docket. A great deal of the work done in patent reform originated in this committee. I think we're all for it. But look, we're the jurisdiction not of the ITC. The ITC is not really our game. Our game is the Article III courts. If what you're saying here today is 2/3 of the cases don't really belong in the ITC, they belong in Article III courts, but they're in the ITC for one of two reasons. One, likelihood of an exclusion order, which is effectively an injunctive relief when they may or may not be given it under the eBay decision, and the speed to trial. If that's the case, then from a standpoint of protecting the Federal Government, protecting the taxpayer ultimately, shouldn't we find a way to have an ITC level of speed on those cases that would otherwise be or already are in Article III courts? In other words, the time to a decision, if it was accelerated to meet or exceed the ITC, wouldn't that in fact eliminate the government spending money twice, particularly in the cases in which the Article III court may not stay the case?
Yes, I think that would be the ideal solution. I don't think that our federal court system is there yet. But through proposals and different initiatives like the patent pilot program, then maybe we will get there. Okay,
so let me just ask one follow-up, though. This committee was very involved in the SOPA-PIPA discussion. You may have heard that. During that discussion, sometimes truth is the first casualty. There were a lot of statements made, but since I have you here, is it true that the ITC is less administratively burdensome, less expensive, and quicker to decision than Article III courts?
I think that the schedules are compressed, so it's actually more expensive in a shorter amount of time. Many of the cases do not settle, and so usually the cases are more expensive to litigate, but they are litigated on a faster basis.
But that's a question of cases that are not settled. I mean, if you take out the ones that aren't settled in an Article III court, they go longer, cost more, and I don't know about everybody else here, but I, for one, have paid those multi-million-dollar legal fees. I will tell you that your expense goes up during time, often more than actual work. Every month you're in litigation, you have a certain large amount of money for reevaluating, rethinking, redoing. So the reason I asked the question is, during that discussion, when we were looking at, and I still have a bill, that would move intellectual property in the case of overseas piracy of copyright, move some jurisdiction into the ITC, many people wanted to say that it was likely to not be able to quickly expand, as though we can get federal judges quickly in Article III, and that it would be more expensive and take longer. Is there any basis under which you think that would be true?
I think that the ITC has proven able to keep its deadline of trying to keep cases resolved as quickly as possible, and that they have experience in doing that and doing it well.
Thank you. Mr. Chairman, I thank you for the opportunity to ask questions that were tangential to today's hearing, but important to, I think, the committee, and I yield back.